thank you for coming out on a Friday evening. I thought we'd go a little faster today, but I think we're not going to be able to do that. Today's is actually fairly critical. If you miss this one, it's going to be difficult to get back. So I'm going to take this slow. What we're going to do today is actually really at the heart of how your suit is constructed and how you carry it forward. If you don't get this portion right, there's every chance that your suit will be defective and will fail. So let's just go through this a little slowly. Now before we do that, I want one of you to give me a very quick summary of what we covered last time, but it has to come from you. So I want to see some hands. I need a volunteer, otherwise I will volunteer you. Come on. Wake up, people. Come on. What did we cover? Give it a mic. Sorry, is that on?
We discussed what a cause of action is, how it arises, who is the plaintiff, who is the defendant, when can a suit be filed, what is joinder of parties, what is joinder of cause of action.
Also hierarchy of courts.
Hierarchy of courts.
Also
yes.
hierarchy of courts, and what are the ingredients that are required for a suit, different types of suits, etc., etc. We also discussed in practical terms what happens when you're presented with case papers and asked for advice on how to go through this. Okay, so now let me assume that we've covered this portion of it. And we're at a stage where you're ready. You've given this advice. There will be some check boxes like limitation, jurisdiction, bar of suit. We'll come to all of that. And you're now ready to go forward with your advice for filing a suit. Now for this, you need to look at first, and there's a little bit of an upside down sequence, or not a linear sequence in this, let me put it like that, in which you got to read this. So start now with order 4, institution of suits. It's a very small order, but there are 2 words in this that are critical, which you will now understand. It says suit is to be commenced by a plaint, and the order's caption is institution of suits. The institution is not like a bank or a court. Institution is instituting it, starting it. And every suit is commenced by and only by a plaint. Plaint, suit, there is no other proceeding that is commenced by a plaint. This word is mandatory. Every suit shall be instituted by, this other word is important, I'll tell you why in a minute, presenting a plaint in duplicate to a court or to a court officer. Then order 6 and 7 are applied, we'll come to those. And 3, it is not duly instituted unless it complies with sub-rules 1 and 2. That is sub-rules that you read, that it has to be a plaint and must comply with order 6 and order 7. The only other thing here is that the court maintains a register of suits, which you don't have to report. Now, once you have read this, do not go to the next order, which is issue and service of summons. It will make no sense. We'll come back to that. You have before you, remember, now a section that, can we turn this on? That tells you that you have to institute or commence a suit by presenting a plaint. To understand what that means, you have to read 2 orders sequentially and then go back and then come forward again. First, You've heard this term pleadings. Okay, what is a pleading? Is an affidavit a pleading? Is everything you file in court a pleading? Not a precedent is not a pleading. What according to you defines this word pleading?
Pleading is basically the base of the suit.
Very good. Not necessarily of the suit. But you need to develop that a little more accurately. What the word pleading itself tells you that this is what is your plea before a court. Now, after you've read Institution of Suits or Reform, look at Order 6. I'm telling you there is a logic to how this is done, but you need to be able to navigate this. So we started with Institution of Plaint. Now we are looking at pleadings, because every suit needs a plaint. A plaint is a pleading. What is a pleading? Pleading shall mean plaint or written statement. Right? So that gives you now the box. It's a definition of what is a pleading. But that's not enough. It then tells you, sub-rule 2, that there are certain forms that are in the appendix. That's okay. But look at sub-rule 2. And this is where I really need to spend time today. You will, I guarantee you, get derailed in the suit and in practice unless you have a clear understanding of what Order 6, Rule 2 means. I'm going to tell you why. Pleading to state material facts and not evidence. Don't be in a rush on this. Pleading to state material facts and not evidence. Every pleading shall contain, now look at the next 3 words, and contain only. So there is a prohibition. It cannot contain more than this. A statement in concise form of the material facts on which the party pleading relies for his claim or defense, because a pleading is a plaint or written statement, as the case may be. But there's a second prohibition, but not the evidence by which they are to be proved. Let's finish it. Every pleading shall be divided into paragraphs, numbered consecutively, each allegation being contained in a separate paragraph. Dates, sums, and numbers shall be expressed in the pleading in figures as well as words. Leave aside sub-rules 2 and 3. Rule 1. Somebody, for me, pick out what, according to you, are the key words in Order 6, Rule 2. Yes? Sorry? Material facts, 1. Then evidence, just the keywords. Evidence. Then concise. Got this? Now, use this as a mental image. You're sitting in this chamber, you've got this stack of papers in front of you, given to you by a client. What is this that you have got? Is it material facts? Is it evidence? What is it? What have you actually got? What's the difference between the fact and the evidence? This is where you get clean gold. This is where, if you don't understand this, you can't get it right in a print. What's the difference between material fact and evidence?
Facts. So facts are orally as well as whatever the material we have, documents.
Where will you find a definition for nothing else? where will we find a definition of fact? What is a fact? Alright, so let's look at the Evidence Act. These are not things that are in silos, not to be read separately. Okay, so I'm just telling you. Now, fact means and includes, so this is inclusive, not exhaustive definition. Now, all of you who spent your time watching Boston Legal and Ali McBeal, be prepared for it. There was a surprise that's coming in, okay? Anything, state of things, relation of things, capable of being perceived by the senses. Any mental condition of which any person is conscious. Now we'll do a separate thing on the Evidence Act, but let me tell you this, when you're reading the Evidence Act, this section has the substantive portion, the illustrations will explain it to you. That's the way to read the Evidence Act, both. Now, these are illustrations. Let's just look at them, there are 5 of them. There are certain objects arranged in a certain order. Here's a table, here's a book, here's a spectacle case, here are specs, here's a glass. Is a fact. That a person heard or saw something is a fact. This will be important when at some point you understand what is meant by hearsay. Every legal show gets it wrong. Every single one. Without exception. That a person said certain words. I've said this to you today. That is a fact. There is a distinction between what is a fact, that is something that is perceived, and the truth of that fact. 2 different things. Alright, let's just go up. Now look at this. That a person holds a certain opinion, has a certain intention, acts in a good faith or fraudulently, or uses a particular word in a particular sense, or is or was at that specific time conscious of a specific particular sensation, is a fact. With me so far? Now come back to the CPC. You have to plead the material facts. You cannot plead the evidence. Why not? Why don't you just plead the evidence? Just bang in everything except the kitchen sink. Something will come out of it. Why not? Why does the CPC say your pleading must contain facts and not evidence? Very good. Evidence requires proof. What does that mean? Wait.
So on the basis of the facts which are pled, the defense will deny something on which that will be a defense which will be tested.
Correct.
That's
There will be a statement of facts which will either be admitted, denied, or not admitted. There's a distinction. We'll discuss this with you. On that basis, both sides will then marshal their evidence and prove their respective cases. But now here comes a very critical juncture. You will find judgment after judgment of the Supreme Court saying that without a foundation in pleadings, no amount of evidence can suffice. And no evidence can be led unless there is a foundation laid for it in pleadings. This is why I'm taking time here, because this is critical. So now please try and understand what is a statement of material facts, and give me an example. A statement of material facts and a piece of evidence to prove those material facts? Take anything you like.
I was at a restaurant yesterday. There's possibly be the fact. To prove it, maybe a receipt.
Okay.
Oh, okay, sorry. Maybe a receipt of it, or maybe the waiter serving me.
All right. Let me put
speaking of
it this way. This often happens, and there will be illustrations in the Evidence Act, which we'll do at some point, where a question is, if a person was in Mumbai on a given date, all right? His answer, for instance, was, I was in Calcutta on that date. How does he show he was in Calcutta on that date? There is a hotel receipt, there is a taxi receipt, there is an air ticket, or a boarding pass, or minutes of a meeting that he held in person in Calcutta. You see the distinction between what is the fact and what is the evidence. Another example.
Purchase order for goods which were delivered showing proof of receipt.
So what is the fact and what is the evidence?
The fact is that the goods were delivered, and the evidence.
So
is
how
that
would
the
you
proof of
plead
receipt.
this?
Um,
I'm pushing you into getting to what you're pleading in your plaint is. You're getting there.
Yeah. So in my plaint, I would state that on a certain date goods were sold, and I would annex a document stating that.
Forget about annexures, because that's a very bad Bombay High Court original side
Okay.
practice. It's in the official, in the districts, we don't annex things, we just put the whole thing into a compilation. I'm only asking you, separate the pleading from the evidence. So in your case, which is the evidence?
The evidence is the proof of receipt of taking the goods, like a signed
So a
consignment.
lorry receipt, gate receipt,
Yeah.
something that shows or a dispatch register, an inward register, these are items of proof. Alright. How would you prove? Okay, take one more example. Partition suit. I have a share in property. I'm a co-owner. I'm entitled to partition of this property. What, according to you, is the necessary pleading that is required here of a material fact?
So that there is an
Or let's complicate this. My case is that I am the owner of this chunk of land because historically this was owned by the family and there was a partition in the family. The material fact is that there was a partition. You have to plead the partition. That is the material fact. How that partition was effected, by oral understanding, by a physical division by metes and bounds, this is a matter of evidence. But now let me invert this. And there is now case law, recent case law, you'll find a judgment of Justice Sudha Chudulia of 2023 or 24 on exactly this. No partition is pleaded. None. And evidence is sought to be led that there was a partition. Can this be done? Now, there's a logic behind this. It's not stated in the CPC, but it's a foundational logic. Why do we prohibit evidence from being led without a foundation? Just think about it.
Okay, sorry, because it opens a Pandora's box of what can then be pleaded subsequently, or what can be proved openly.
we can't take the other party by surprise.
War. Nearly hot.
Other side didn't have to reply. Didn't have a chance
The
to
defendant must know the case it has to meet. If you are not going to make a pleading, how do you as the defendant put in a written statement saying there was no partition? There was never any partition. How do you put in the statement that I was in Calcutta if whether I was in Calcutta or in Bombay has not been pleaded at any stage at all. Can't be done. So this becomes wrong. Give me another example. One more, because I'm just hammering this in because we really have to get this sorted. One more example of a material fact and evidence. Now look, I just want to tell you, this is actually so central that if you have any doubts, I want you to stop me now and we have to discuss it now because we're not going to be able to revisit this as we go along. Okay, one more example. Couple more examples so that we have a fuller understanding.
So there's a suit for the title, like claiming ownership.
Title of what? Land?
No.
Land.
Land or
Okay.
flat. And now to prove it, you have to show like a registered agreement from when you.
No. Now you're muddling things. This is what I don't want. In a plaint, what is the averment you will make? What is your statement of material fact? Frame it for me, please.
That you were owner of 100%.
What is the material fact? Identify the fact first.
I have purchased this property from so and so.
Correct. That on this particular date, the plaintiff purchased a particular tract of land or a flat or whatever it is under a sale deed dated so and so, which was registered. This is the fact. This is the fact. Actually, the fact is, the only fact that you need to state is not even the document, but the fact that you are an owner of the piece of property. That is the fact. You're proving it by a registered document is a matter of evidence. Though, of course, everybody says by an indenture of assignment, etc., etc. Technically, absolutely correctly, the only material fact is that I am the owner, not a tenant, not a lessee. I am the owner of this land since a particular date. Finished. Finished. Come on, now one more example.
In a testamentary matter where a will exists, the date of the will and what.
Just use the mic, would you, so that it gets recorded.
In a testamentary matter where a will exists, the material fact would be what is bequeathed in the will and the date of the will, and then the evidence led on it is when the will is tested.
In a contested testamentary matter, actually this won't, it's a peculiar type of provision.
Okay.
Because technically there is no plaint. It's a petition for probate which proceeds on the footing that is uncontested. A contest arises when there's a caveat and an affidavit in support. It's a slightly different color, but in fact that's a bad example because there's an affidavit that is converted and treated as a written statement. So it's a little strange. We'll come to testamentary actions later. Give me something in a regular suit. Yes. Take a mic there, please.
So I am a builder and an offer was made by a company to supply me with raw materials. So that is my material fact, and the email correspondence making the offer would be an evidence.
So could you rephrase that in the form of a pleading? You're drafting it. ChatGPT is not going to do this for you. So don't go to Harvey. Tell your boss to get you a subscription to Harvey or whatever it is. It's not going to happen.
I'm sorry, I can't.
That's the point. That's what I want you to do. And you're not leaving here till you've done it. So with this, now somebody please frame that one line averment in your plaint. There's a builder. Somebody offered to supply, let's be specific about it, cement. Offered to supply cement. What's the pleading?
So this company on specific date, some company on a specific date offered to supply me cement at this price, and this was then I accepted by this email.
You don't say I in a plaintiff in the first place. You have to say the plaintiff.
Plaintiff.
Again, precisely what will you say in the plaintiff? It's going to be settled by me. So you're going to get into all kinds of trouble here, right?
Defendant was supposed to supply the raw material.
Defendant was supposed to supply raw material.
Agreed.
Just define the fact.
Defendant.
Define the fact in this example.
ACC agreed.
Hold on, wait, he's still struggling. So I want him to suffer. Wait.
Defendant agreed to supply
You're
cement.
framing it. I want you to now just go back one step. Define the fact. What is the material fact?
Defendant made an offer.
There was an offer to supply cement.
The defendant offered to supply me cement is the material fact. Okay, now let's have a pleading. Material facts. Now put this, you've identified this chunk as a material fact. Okay, let's cast it in a plaint. Yes, there's enthusiasm in the front row.
The plaintiff states that the defendant has offered
What happened in the past?
The plaintiff states that the defendant had offered a pack of, a lorry of cement.
When? Dates not important?
Yes, absolutely.
Very good.
On so and so date, and for this, on this, the plaintiff has paid such and such amount
As advance or
as part payment towards the.
Alright, so we're getting somewhere. So part payment, offer of supply, you missed something in this in the contract act. If you said there's an offer, there has to be an acceptance of it. So now the acceptance is a fact. So if the defendant on so and so date, the defendant, comma, a supplier of construction materials, comma, offered to supply to the plaintiff a quantity of 500 tons of grade 1 cement at a price of rupees so much per ton. Full stop. The plaintiff accepted this offer by a letter dated so and so and paid so much as advance. Full stop. Pleading? Material facts? What's the evidence? Correct. Now the suit for specific performance, which I guarantee you is going to get you faster than you think. Give me an example of a pleading, of a material fact. Necessary pleading of a material fact, without which your suit will fail. Willingness and readiness to perform. So very good. The willingness and just remember this in terms of the definition of a fact. We'll just go up again just to look at the main thing. You have to look at this in a specific performance suit. Mental condition, capable of being perceived by the senses, all of this. Readiness and willingness has to be pleaded. It also has to be proved. They're two separate things. We're going to deal with that. The pleading is, I was at all times, the plaintiff was at all times ready and willing to perform his obligations under the contract for sale. It's the pleading. What is the evidence to prove this? Readiness and willingness. Readiness and willingness to do what? Not to nod and say, हाँ चलो करते हैं. What's critical to a specific performance suit? Money. Tender thing? Is that required? Is that the law? Suppose I don't tender it, does my case on readiness and willingness fail?
No.
What's proof of readiness and willingness?
You should have the sufficient funds in your bank.
Do I have to have them in my bank account at all times? That's not the law either. Additionally, if you have them ready, additionally, if you've offered to pay, readiness and willingness is everything to show that you are prepared to proceed with the contract, completing your end of the bargain. Now, on this, I wanted to pause for a moment. We're moving away from the CBC again back to the Evidence Act. Now, this is a new Evidence Act. It's slightly different from the old one because one definition has for reasons that escape me, being taken out of it. And this has been inverted. There's no logic to why it's been inverted. But start here with proved. A fact is said to be proved. Now please just pause for a moment. Remember this, we are again using this word fact, which is something we saw in the Evidence Act, but which we've also seen in the CPC. A fact is said to be proved. So now we have come from pleading a material fact to proving the material fact. I need you to make this bridge. You can't just make a pleading and hope for the best. The point I'm making is that whatever pleading you have, it has to be with one eye to what you can prove. A fact is said to be proved when? This is where it's counterintuitive. After considering the matters before it, the matters, which means pleadings, evidence, everything, oral, documentary, the court either believes it to exist. This is not an absolute standard. This is not an absolute standard. This is not the truth with a capital T. This is believes it to exist, or even worse, or better, depending on your perspective, considers its existence so probable, likely, that a prudent man ought, under the circumstances of the particular case, to act upon the supposition that it exists. Read this again slowly. A fact exists. When is it proved? A fact is said to be proved when the judge or the court believes it exists or considers its existence so probable that a man of ordinary prudence should, in these circumstances, act on the belief, supposition that the fact exists. Not proved. See, this is the whole problem with this act. A fact is said to be not proved when it is neither proved nor disproved, and they took out the definition of disproved. Don't ask me why. It was there in the original act and it was there for a reason, because disproved is the exact mirror image of this in the old act, and it says you might as well know it. A fact is said to be disproved when, after considering the matters before it, the court believes it not to exist or considers its existence so improbable that a prudent man ought, under the circumstances of a particular case, act upon the supposition that it does not exist. And not proved is that grey area in between, which we're going to discuss in a minute. So now let's stick with proved. Now what this is telling you is that the structure of your plaint must change and must always be with an eye to the Evidence Act, and particularly the definitions of fact and proved. I'm asking you this. I said you have to learn to tell a story in a compelling manner. Right? What is your target? What is your goal in your plaint when you're setting out your client's case? Are you just going to recite these material facts and hope for the best, pray for an act of divine deliverance? Or are you going to structure your case so that you can persuade the court to believe that the facts you outline exist, or that the preponderance of probability is on your side? Why is this important? Because there will be facts that you can't prove with documents. You may have oral evidence. There may be facts which are the implication or necessary consequence of other facts to be proved, all of which is in the Evidence Act. This we'll have to see in detail when we see the Act, but remember the Evidence Act is not to be seen disjunctively from this, because there are sections here which says facts are relevant when they are necessary to prove other facts in issue. Got it? So, therefore, this distinction between material facts and evidence, underlying principle, the defendant should not be caught unawares of having to deal with evidence. Evidence is a shape-shifting beast. It will take different forms. But the foundation of it, that is to say, your entitlement to lead that evidence must exist in your pleadings. That is your case. If your case is not that there was a partition of the property historically, how can you possibly make up the story of a partition at a later stage? Or to take this example, if the defendant never made this offer to you to supply cement, how can you raise this in evidence in the plaint? It can't be done. Got it? Alright. So, any doubts, questions, please stop me now, because this is really fundamental to where we are going with this. So, sure.
So, if you're talking about
trying to keep as much in your pleadings that you can eventually substantiate with evidence, likely that you
only as much as you need for your relief.
So how do you deal with, say, oral evidence? Or, you know, how do you, like, something that happened, but I can't actually show a document for it. How do you deal with that in your pleading?
Because of the definition of a fact
So you,
and the illustrations for it. The fact is that you asked me this question just now. Forget it, let's assume he's not recording it. There's no record of it.
Yeah.
Say this as a fact. You can't let in any evidence of it, documentary or oral. Are we clear about this? I'm not going to get back to this, so if you've got doubts, let's get this out of the way first. Yes.
So
It's not easy, but so let's spend time on this. Yes.
if I manage to prove something, I'll get what I want. But what is the difference on effect if I do not prove something or
Okay.
disprove?
So let me put it. Let me try. Let's see if I understood the question. Your pleading is in place, but you have failed to prove it. That's the question.
Either that
Or
you have, like, the other party has disproved it.
that's okay.
What will happen to your?
That's alright. That's a good question. It's a case for worry. We will see that in a minute, because that's the perspective from the other side. I'm not there yet. I'm only on this question. I'm not on whether you succeed or fail. I'm not on whether your evidence will actually convince the judge or the court. I'm not on whether the judge will consider it likely, probable, act on the supposition, believe it to exist. I'm not there yet. I'm only saying that when you are drafting the plaint, please understand from the papers in front of you what's evidence, how you're going to prove it, and what is the pleading that you need to make of a material fact. Okay? This is an important, Order 6 is important. Please look a little further. And Order 6 Rule 4 becomes critical. By the way, listen, I forgot to mention this last time. We will do the rules, but remember that in the High Court, in the CPC, there are state level amendments. So there are amendments for Bombay that we will also have to look at. They don't exist in the parent CPC, and not all other states have applied them, but we'll come to that. Okay, Order 6, Rule 4. These are important, these are categories. And every one of them must be understood clearly to get an understanding of what we're talking about next. In all cases in which the party pleading relies on any misrepresentation, fraud, breach of trust, willful default, or undue influence, and in all other cases in which particulars may be necessary beyond those that are exemplified in the forms aforesaid, particulars with dates and items shall be stated in the plaint. Means what? Here's the difficulty. The essence of fraud is concealment. If you knew everything, you could not be defrauded. You defrauded because things have been hidden from you. Correct? What does material particulars of fraud mean in the context of a pleading of material facts? What are these material particulars for fraud, undue influence, and so on? Meaning what?
So, for fraud, as it's mentioned, so we can say that a person has changed the date so that they can
Change the date of what?
change the date of any document that is required for the suit.
That's forgery. That may be forgery. Not the same hand again. Someone, give me an example, or give me an example of a case of fraud. A civil case of fraud. Okay, let's start. Wait. Fraud, difficult. Undue influence. You, again? Yes. Someone else. Come on, guys, who are asleep through this class. Yeah, come on.
The material fact would be that you came to know about the information after you entered into the contract and you were not aware of it before entering into the contract.
How is that undue influence?
No, that this was a fraud. Concealment. You have to prove that you came to know about the information only after you entered into the contract. While entering into the contract, you were not aware of it, and therefore,
or led you to believe otherwise.
Led you to believe otherwise.
Correct?
Yes.
Material fraud, because that's a state of mind. It's a mental condition. You will plead to that by words of such a kind, or by acting in a certain manner. The defendant induced you to believe or led you to believe this, and this happened on a given date when he was doing something else on the side against you. These are the material particulars, but to the extent that you know them. This is critical because you cannot plead to things that are not to your knowledge. They are not going to be to your witness's knowledge. How is somebody ever going to give evidence? That is a conclusion that you will invite a court to draw once you lead your evidence in. But you can't just say, what is the section tell us, the rule tell us? You can't just say fraud. You can't just say undue influence, because these are labels. In themselves, they are not facts. You have to provide sufficient particulars that lead to a conclusion of fraud or undue influence or coercion or misrepresentation. The defendant represented to me, to the plaintiff, that the defendant was the owner of a classic original Rolls-Royce motor vehicle. On that representation, the plaintiff was persuaded to pay an advance of so much. The car didn't actually exist, or instead of a Rolls-Royce, you got something else. Statement of material fact. Okay, so I'll let you break free now.
It's anything that causes the consent
So,
not to be free. So
correct.
yeah.
So this undue influence will become important when you're doing testamentary matters, because it is a classic case where you say that so-and-so leaned on the testator to make a will that she or he would not otherwise have made but for the exercise of undue influence. And there is enough law which says that not all influence is undue, and hardly anybody goes through life without being in some way influenced. Love is not undue influence. Love for a family member is not undue influence, and so on and so forth. Okay? Alright, now, you will bear this in mind, because now Order 6 is your guide, is a set of must-dos and don't-dos when you are drafting your pleadings, both plaint and written statements. You ignore this at your peril in practice, and therefore an understanding of this is important. Now, further and better, 6, condition precedent. Now look at this. 6, 7, 8, 9, 10, 11, 12, 13, and then we'll come to 14, which is purely procedural. 6 to 13 are instructions from the CPC on points of substance, substantive stuff. A condition precedent, the performance or occurrence of which is intended to be contested, shall be distinctly specified in the pleading, and subject thereto, an averment of the performance or occurrence of all conditions precedent shall be implied in the pleading. What does this mean? What's an example of a condition precedent? You'll find this everywhere in commercial law. It's one example. Complicated. A very good thing that happens in transactional cases, specific performances for suit for land, is that I must have clear title as a condition precedent. If I don't, my other obligations are not to be fulfilled. It could happen in more complex financial transactions where there are two parties in a financial dealing, and the dealing is that if you perform this and pay me this, then I have to do X, Y, and Z, issue you shares or whatever it is. The condition precedent has to be clearly identified and must, because it is a material fact and needs to be pleaded specifically. It cannot, but look at the last lines. An averment of the performance or occurrence of all conditions precedents necessary for the case of the party shall be implied. That the condition precedent was met or that the performance was done is implied, but the condition precedent is the fact that has to be pleaded. Okay. 7 is something that we come upon all the time. It basically says that you can't introduce a new claim unless there is an amendment or contain inconsistent allegations of fact with your previous pleadings. There is a suit filed in the City Civil Court, and there is a suit filed later in the High Court. The party in the plaintiff is the same. The plaintiff can't take diametrically opposite positions in these two proceedings. There's a prohibition here. The pleading will not be sustained. Now, contractual denials, where a contract, this is your cement supplier, is alleged in any pleading, a bare denial shall be construed only as a denial in fact of the express contract alleged, and not as a denial of the legality or sufficiency in law. What does this mean? Think.
Denial, this, from my end, is denial, you are just denying the contract, but not whether the contract was legal.
That's correct. The legality, the denial is of the existence of the contract, not of the legal relations. This supply could have happened without a written document, could have happened merely on paper, the contract, on payment. That's a possibility. Effect of document, please state. Whatever the contents of any document are, whenever the contents of any document are material, now these words are important. It shall be sufficient in any pleading to state the effect thereof as briefly as possible, without setting out the whole or any part thereof, unless the precise words are material. Everybody. That's for all this. I'm fed up of the number of plaints and petitions I've seen where there is an endless recitation of all the correspondence from the dawn of time. I don't need all this in a pleading. You will at some point have correspondence that goes on and on between advocates, where one advocate makes a claim, the other side denies it, this one in rejoinder reasserts it, the person re-denies it, and this goes on. Let me assume that this is a simple case where your client is demanding money from the other side for goods sold, supplied, and delivered. Right? This correspondence is there. The other side has raised a defense that the goods were short delivered, less in quantity, were not of the prescribed or acceptable quality, and therefore it is not liable to pay your demand. Now there are 15 letters like this. You tell me how you would deal with it, having regard to this. The 15 letters on both sides. 8 letters from the plaintiff, 7 denials from the defendant. All saying the same thing again and again and again. Are you going to go through each letter? Now just be very clear about this. Are you going to go through each letter one by one, saying by a letter dated so and so, by an email dated so and so, addressed by so and so, to so and so, he did blah blah, yada yada yada? Are you? What are you going to do instead? So now please, let's have that pleading. Don't let's talk about what you are going to do, let's actually do it. Let's have a pleading. How do you summarize this?
So the petitioner from so and so
Plaintiff.
The plaintiff from so and so date has made several representations to the defendant.
Why would I make a representation to the defendant? I made a demand. He is not the government.
Has made several demands to the defendant. Then all the
Demands for what? For payment.
Yes, for payment.
Ah.
It could be for payment.
Yeah,
or
but
the
it's only for
quantity.
payment
Okay.
in this example.
For the payment,
And?
but has received no response or has received response stating that the entire amount has been
Alright,
paid.
somebody now make this a little neater. She's there. Take a shot. I want a compact pleading because it has to be concise. It has to state material facts. Now let me ask you, is each letter a material fact or is each letter evidence?
Evidence.
What's the material fact? Good. Get it. So the material fact is that a demand for money was made. The letters are the evidence which will show that such a demand was made. You don't plead to that evidence. And you have a chain of correspondence. It is sufficient under this to give us the summation of this. Correspondence ensued between the advocates for the parties, in which the plaintiff's advocates repeatedly demanded payment of the amount of so and so from the defendant. The defendant raised various false, frivolous and untenable defenses and denied liability to pay. Finished. Finished. This is correspondence. You don't need anything more than this.
Would it make sense to maybe give the date of, say, the first letter?
Yeah.
Say that that's the first time I made it.
I would give a date range between so and so
yeah,
and so
correct.
and
To just
so. You
that.
pin it down to that this
that.
correspondence is in this time frame. You're stating what? The effect of the document. Now, there's a sting in the tail here. The precise words or documents are material is important because somebody raises a particular plea that you have to deal with. A quotation. Somebody says, for example, in this thing that we do, that you've already been paid. The defense will have to deal with. That can't be summarized. Or is a point of jurisdiction, or whatever it is. Anything that is required to be quoted, that much you will do. But otherwise, a summary is enough. The summary is always enough. Alright. Malice, number 10, is to be read in contrast to form. And you have to tell me why. Wherever it is material to allege malice, fraudulent intention, knowledge, or other condition of mind of any person, it is sufficient to allege the same as a fact without setting out further particulars. Tell me why. Yes, it's a state of mind. What can you do except plead to that state of mind? You can't have further particulars. Don't confuse this with sub-rule 4. You can't ask somebody in as a defendant for further particulars of malice. Malice is a form of conduct, a thought process. Correct. Notice and notice is important. Why? In a land sale, notice that the purchaser had notice of a prior transaction is a fact. It is a material fact. It is going to have to be proved. But you don't have to say anything more than merely say that there was such a notice issued in the newspapers. Unless there's a particular form that is important. Notices are sometimes required to be in a certain form, so then the form of the notice becomes important. But otherwise, that a person had notice, the notice itself is the fact. Alright. Implied contract or relation. Whenever any contract or any relation is implied, What's an implied relation in correspondence? Tell me. Or conversations. Now let me finish this. It will be sufficient to allege such a contract or relation as a fact and to refer generally to such letters, conversations or circumstances without setting them out in detail. I guarantee you that your senior partner will throw you out of the office if you don't put in the detail. And they've all forgotten this. This is your answer. It's not necessary. The senior partner will say, but where does it say it's prohibited? It just says bloody bad form. And if in such a case the person so pleading desires to rely on the alternative upon more contracts than applied, he may state the same in the alternative. Now let's take an example of an implied relation between parties from letters or conversations.
If I have purchased a
Mike. Implied relations are of various kinds. So there could be different kinds of implied relations.
So, for example, in a contractual relation, I have purchased a mobile phone from you. There is correspondences, WhatsApp chats where I have asked when will the phone be delivered to me. You have replied with it shall be delivered.
What is the relationship that you are trying to say is implied?
Contractual relation.
It's an implied contract. What about things like trusteeship? Held in trust. There are all kinds of contractual relationships that may come into play in a situation like this, which will happen in the form of a conversation or a series of. For example, somebody borrows something and doesn't return it. There's a relationship happening here. These are all civil matters. These are all civil rights. This is what is beginning to happen. Alright, let's just finish this quickly. Neither party in any pleading needs to allege any matter of fact which the law presumes in his favor. Not just mark this. These presumptions are in the Evidence Act. Or as to which the burden of proof lies on the other side. Unless there's already been a denial, and here you will find an example. Consideration for a bill of exchange, where the plaintiff sues only on the bill and not for. Does anybody understand what this means? All right. What's a bill of exchange? What's a bill of exchange? Even your lot should know it. What?
When a bill of exchange involves three people, where you direct someone to pay
Correct.
one person on your behalf.
Simplest example of a bill of exchange is a check. Correct? Check is dishonored. But the check has been issued for a purpose. I am only suing on the dishonor of the check. My brain says nothing about the reason for which the check. That's what this says. If I am only suing on the check, I don't have to give the particulars. If I am also saying because there was a relation, implied or express, and in payment of that obligation he issued a check that was dishonored, then I am suing on both the underlying contract and the instrument. I can sue only on the dishonored bill, the dishonored check, without talking about, because the Negotiable Instruments Act and the CPC, as we see, allow that to happen. Okay, is all this making sense yet? Getting some structure to this? Now, forget about 14 and 15 you read on your own and verification, so I'm not going into that. Order 6 Rule 17 is critical. And I expect, though I haven't seen it, that it will be a stock question in some exam paper because it deals with amendments. Very broadly, after the change in the law, and this you will look up and tell me next time, what are the situations in which an amendment will not be allowed to a pleading? Number one. Number two, what is a factual scenario in which a defendant would be entitled to amend the written statement? Amendment of plaint, I understand. Amendment of written statement, be careful with this. Okay, now two things I'm very quickly going to do, and then we are going to the rest of it. Now this is just pleadings, okay? So we've gone today from institution of suits to pleadings, and now you come to order 7, which is the plaint. Order 7, rule 1. Very interesting because this now introduces, what's the time? Introduces concepts that we find undefined in the Act, including cause of action, which you will find in Order 7, Rule 1E. Now, you will find any number of suits filed that do not have a cause of action paragraph. It requires one paragraph in your plaint of a cause of action and when it arose. We understood the definition of cause of action. Now we've seen institution of suits. We've seen pleadings. We're now at the plaint. And the plaint now demands, CPC now demands that the plaint must have the facts constituting the cause of action and when it arose. I want an example. In a suit for specific performance, I'm going to take 2 or 3. In a suit for specific performance, give me and frame it right now. A cause of action paragraph.
So and so the defendant refused to perform this part of the contract.
No. Absolutely not. That's not a cause of action. This is what was worrying me.
The plaintiff states that in context of developer agreement,
I have partition, I want a suit for specific performance for sale of a flat. I don't want to go all over the place. I said take the mic, even I can't hear it very well.
There was a MOU and there was a refusal to go ahead and sell the flat or sell the land. So then we mentioned as the cause of action, we mentioned in the pleading that on so and so date, so and so refused.
You're going about this all wrong. When you have a suit, you are clear about what relief you are seeking. The relief in a suit for specific performance is what? First pair is what? That he be directed to specifically perform his obligations under that contract.
Because compensation would not be adequate.
And in the alternative, if it cannot be granted for any reason, then damages in view of specific performance. This is the classic form of a pleading in a suit for specific performance. performance. Correct? So what is the cause of action? Read this again. The facts constituting the cause of action. Look, it has to be concise. Your narrative from the beginning to the end in this trajectory of a specific performance suit has certain well-defined steps to it. So we're going to take this one, just a specific performance suit. Okay? So when we've got a specific performance suit, there are now 2 or 3 elements that you're going to bring into this. Okay, the first of these is the contract. Correct? How the contract comes into being. Whatever, the various steps. The second are the obligations. Yeah, why you put up your hand? I haven't asked you a question. You have a doubt? What?
So, what is question that you said of drafting?
Hold on a minute. The second is the obligations. Correct? The third, obligation of the defendant. So far as you are concerned, readiness and willingness. And fourth is failure. This is a fact. This is treated as a fact. Failure of the defendant to perform. Correct? This is your suit. Now your cause of action paragraph will summarize, not repeat, that a valid, subsisting and binding contract was arrived at. Firstly, under which the defendant was obliged to do X, Y, and Z, and that although the plaintiff was at all times ready and willing to perform his obligations, the defendant failed to do so, as a result of which the plaintiff is entitled to the relief of specific. That's what a 7 rule 1. And you'll have the date when it arose, that the cause of action arose. When? Now, when did it arise? Which of these 4 stages did your cause of action rise? Here. So this failure will actually be seen as a refusal, and you will have to put a date to it. This is necessary in your plate. Yeah.
So this failure means from the date when you refused, or this failure when you understood as refused, but not as in
You communicated with him.
communicated.
How do you know he refused?
Exactly.
You call upon him and he doesn't act.
He doesn't.
You can argue that you send him 10 reminders and he's done nothing to take the last of the reminders.
So for example, suppose under the contract, a particular date is there, he has to perform.
That's correct. That is also material.
Yes.
And where time is of the essence, that is also material. If the contract says so specifically.
So my cause of action will be that date of the contract, or it will be
It will never be the date of the contract.
So when
it will be the date of breach.
Date of
It will be the date of breach, the date of refusal to perform. Alright. Now, the money suit proportion, leave aside the mean profits, you'll get a question on the mean profits. You have to be precise about the exact amount in rupees annas by say. You can't be gentle, waffle about this. 3 is important. You have to describe the property. Order 7, rule 4. If if you sue as a representative, the plaint must show, this is different from order 1 rule 8. Plaint must show that you have an existing interest in the subject matter, you yourself, in addition to order 1 rule 8. Got it? Right. Then, defendant's interest and liability to be shown. You must explain limitation law. Sorry. You must explain limitation law. I'm just going through this very quickly because there are two portions here that are going to be difficult. We'll do that next time. You have to have the relief specifically stated, individual grounds, and then there's order 7 rule 9 says procedure on admitting the plaint which has been presented. Now, order 7 rule 10 and order 7 rule 11 are hot favorites with your return of plaint and rejection of plaint. The words are different. So now let me hear this from you. Okay, let's do this. We'll run out of time. Okay, we'll run out of time today. We'll pick it up from here. We're going to do written statement. The written statement has some complications which set off and counterclaim. It will be a longer session. We'll take a break in between, but it will be a slightly longer session. I want you next time to tell me the difference between return of plaint and rejection without citing Supreme Court. No, anyone can do it. So I want to know what is your understanding. And I'm giving you a hint. There's one judgment of the Supreme Court. Came up to the Supreme Court from Chennai. It's by Justice Nariman. Have a look at it. We'll need to discuss it. Can a plaint be returned in part? Can a plaint be rejected in part? Good. Little bit of head scratching, little bit of read this stuff. This is important because this is what I call the tripwires that are set for you as an advocate for the plaintiff. You hit that tripwire and your plaint just goes kaboom. Right there. It's total carnage and chaos. And this is the one thing that you do not want. But let's be very clear about where we are with return and rejection of plaint. Okay, we'll see this next time. What do we first? First part. Alright, fine. So we've got some dates, we'll tell you as we go. And we've got some thoroughly unpleasant surprises.